Yes.
Yes. Both these matters notes has come as per the request of the Honorable Supreme Court.
As per the request of?
Honorable Supreme Court of India.
As per the direction of Honorable Supreme Court.
Request Honorable Supreme Court has used.
Supreme Court has used the word
that is
request, but it is a direction to us. All right. What is the matter?
The matter is, Milord's petitioner was the Vice Chancellor.
One is quashing and the other is bail.
Yes.
So let us see bail first. Yes.
Yes. The FIR, Milords, starts from page number 13.
Yes.
Right. The case was issued under section 120B, 420 of the Indian Penal Code.
Just give us a minute. Page 11, disproportionate asset case.
Virus.
No, but what are the offences?
Offences, I used
only disproportionate asset.
only disproportionate assets.
Yes, who appears for the vigilance?
Yes, I'm okay.
Put in your response.
This is much more beyond the disproportionate asset class. A raid was conducted which led to recovery of assets and wealth. And thereafter, in course of investigation, which I may place in my not function.
Yes.
In course of investigation, it came to light in the purchase of OMR sheets, bypassing all the rules and norms.
No, that's all right. That is the background for a massive wealth.
No, this was the raid was the first stage. Whereafter all these facts emerged from the recovery of
No,
the
that's
documents.
true, but you have lost a case under which section? This is, see, you go by the accusation under section 12, 13.2, 13.1b of Prevention of Corruption Act. Not for any conspiracy, for anything. It might come in the process of investigation. We'll see. Put in your response.
120B and 420 is also.
File your response to the petition.
Fine.
What is the quantum of money which has been found to be disproportionate to the assets?
Assessment are still going on. 1 crore 82 lakhs was found in cash
1 crore 82 lakhs in cash where?
from his house at Gorakhpur.
Wrong. Absolutely.
Let me complete first.
Yes. Please don't get into verbal squabble.
1 crore 82 lakhs from his house.
At Gorakhpur.
At Gorakhpur. Thereafter,
Simultaneous raid at his office in
at his official residence at Gaya, which led to recovery of all the papers relating to purchase of OMR sheets and other documents, which was kept at the official residence of DC.
Well, why did you register a case only under 12.13.1d?
Initially, there was information.
No, it is only after the raid that you instituted this case.
The raid was instituted pursuant to the case. The
Why
information
are you soft peddling this case?
No,
Mr. Vigilance?
we are
You're
vigorously pursuing the
you're
matter.
opposing the bail so vehemently, but from the FIR, the accusation
lord,
made in the FIR,
the moment,
you,
my
seem
lord,
to have, you seem to have given him a very soft
My
passage.
lord, the moment I place the fact which has come in course of investigation, my lord will be
The
persuaded.
case is something else. The court is observing something else. From the tenor of your argument, it appears that matter is very serious, and it is something more than what meets the eye in black and white. But what prevented the vigilance from raising all these issues in the FIR? Why have you done this?
Because on the
We must question your conduct. Is this the way you lodge a FIR when you conduct a raid with respect to purchase of OMR sheets? You find 1 crore 80 lakhs from his residence at Gorakhpur, and then you find that as Vice Chancellor of Veer Kumar Singh University also he had done the same thing and the same. Where have you said what are the corresponding offences for which this FIR has been lodged?
All these
Aren't you giving him a very soft prosecution?
My lord, I very humbly, my lord, I say, all these have come, the moment it has come, everything has been jotted down, and we are making
How do we
all
know?
out.
How do we know?
My lord, once my lord goes through the FIR, the case diary. My lord, once my lord goes through the case diary, my lord will persuaded to report. But more than that, my
Where is,
lord,
apart from that, when you got this information, where is the requisition for adding different sections of the IPC in the FIR?
that requirement. For which
So
I
therefore, we find that you are opposing the bail here, but you are not conducting the investigation as a prosecution agency. Perhaps you are giving him very safe passage.
I'll take instruction on this point. I'll take instruction on this point, specific
But
instruction.
therefore, why shouldn't the court grant anticipatory bail to him?
I'll place all the fact. It is up to my lord to consider.
That's true.
Considering all those facts.
Corruption in corruption in educational institutions unthinkable.
Right.
But look at the manner in which you are seeking to prosecute him. You are only talking about the disproportionate asset, and you are not talking about any other accusation. Why?
I'll seek instruction on this.
Vigilance is helping him. And all these facts, not that these facts are yet to come. You are in know of these facts, and therefore you are opposing.
My lord,
But what prevented you from making this?
May I place page
What?
17 of the FIR?
No. What is preventing you from making this prosecution completely watertight?
My lord, we have stated in the FIR. My lord, kindly page 17 and 18.
Or yes. Yes.
Page 18, my lord. Ignoring the advice of the competent officer, directly entered into criminal conspiracy to raise bill to the extent of 12, and thereafter, my lord,
All right. We are not inclined to grant you anticipatory bail, gentlemen.
Let him
The
find out
prosecution
response.
may be going soft on you, but
Lords, let him
educational
file notes.
institution we are not inclined.
Lords, let him file response. We have given supplementary affidavit.
Prima facie, we find from the accusation that you don't deserve anticipatory bail.
My lords, let him file his response. It may be taken up, my lords.
Why?
Directly
We are-
coming
we are-
from
we are-
Visa today.
we are able to make up our mind on the basis of this material only.
My lords, the FIR is concerned. The FIR absolutely there is nothing. my lords. But insofar other materials
What
are
is the
concerned,
just, how 1 crore 82 lakhs did you sell in
my
your
lord, that
property?
was not recovered from my possession. I never resided there. That is a trust. Trust has already filed application for release of that
Where have
money.
you said that?
My lords, I have no information. In the FIR, there is absolutely nothing. The materials which they brought before the learned court below, I have answered. I have also filed a supplementary affidavit including all the documents, the allegation which they are
Both is
making.
heard Mr. Ranjit Kumar, learned advocate for the petitioner in both the cases, and Mr. Rana Vikram Singh for the
SVU.
special vigilance unit which is conducting the prosecution against the petitioner. Mr. One of the applications is for grant of anticipatory bail, whereas the other is for quashing of the subject FIR. The main thrust of the accusation is that the petitioner, in his capacity as Vice Chancellor of the university, had bypassed all the rules and procedural formalities for making purchases of papers and other stationery from different persons, thereby causing losses to the state exchequer as also to the university. Mr. Rana Vikram Singh, learned advocate appearing for SVU, submits that during the course of simultaneous raid in the house of the a simultaneous raid at different places, rupees 1 crore 82 lakhs were recovered from the Gorakhpur residence of the petitioner, which accusation the learned counsel for the petitioner denies vehemently. Apart from this, it has been submitted on behalf of the petitioner that according to the first information report, the accusation is based on assumption, especially that the petitioner may have cornered extra benefits by bypassing the rules regarding purchase of papers and other materials, thereby causing losses to the government. The learned counsel for the SVU, however, has submitted that there are many more graver accusations against the petitioner, which has been unearthed during the course of investigation, which facts he shall bring on record by way of counter affidavit on the next date. Let such an affidavit on behalf of SVU be filed positively by the next date. Re-notify on. You have an interim protection from. I am not interested in granting protection
For
to you.
3 weeks.
3 weeks.
For 3
So we put it
From
before 3 weeks.
4/4/2022 for 3 weeks.
So the
It will
last
still
period
25th.
ends when?
25th.
25th of?
This,
3 weeks ends on this month.
but the order passed on 4/4/2022.
We are not inclined.
There are other grounds. They submitted application before the governor. The governor got it inquired by 2 agencies.
When was the order passed? Let us see the order of the Supreme Court. By what time will you file your response?
In a week time, right?
That crosses
Maybe
the.
kept on 25th one.
All right.
Filing by that.
Periods, it will come on 27th periods.
No.
There is
Then
only
you
30 of my
then you
mother.
remain without protection, and I am not inclined to grant you protection.
Then let it come on 20.
Yes.
I'll come.
Yes. क्या लिखा है पढ़िए?
Let such an affidavit on behalf of SBU be filed positively by the next date.
Be filed positively by the next date. Re-notify on 25th of April. Also call for the case diary. Also, the learned counsel for the vigilance is also directed to bring photocopy of the case diary with him on the next date. Since the petitioner enjoys interim protection by the Honorable Supreme Court, there is no need to pass any interim order in the meanwhile. Both the matters.
Second is there is a different ground.
Let's see. We'll see from that day. We'll
In
see
that
from
case,
that.
counting both the
File
cases.
counter affidavit in both the cases.
In second matter, my lord, this is quashing. So I need extra time. They have taken only ground of section 17A of the PCF.
That's right. You
We have
file a
10 of
counter.
that,
We will
so-
see. We'll give you further time. File an application for seeking further time. We'll do that.
Offline.